Welcome to Wall Street versus Main Street, a different take on the investment show with our host, Dax White. Dax White is the managing partner of the White Law Group, a national securities fraud, securities arbitration, and investor protection law firm with offices in Chicago, Illinois, and Vero Beach, Florida. The White Law Group has represented hundreds of investors in FINRA arbitration claims against their brokerage firms, and throughout this show, Mr. White will shine a light on some of the tricks of the brokerage industry, while also providing valuable information for investors on how to successfully navigate the investor-financial advisor relationship.
Welcome, everyone. You're listening to Wall Street v. Main Street. I am your host, Dax White, and as our lead-in indicated, I'm a securities attorney that represents investors in claims against their brokerage firm. So this is what we're trying to call this a different take on an investment program. We're not here to give investment advice or to give tips on, here's what's going to happen in the market. Instead, the objective of the show is to sort of pass along some of the information that I've gleaned through my practice in representing investors in these types of disputes that I wish the investment public sort of knew before they get to me. Information I think will make it a more even playing field for investors and that relationship with their financial advisor, because it's a critical one. You've got this person who's managing your life savings, and you're making sort of assumptions on both their background and their obligations to you. And you're obviously, your hope is that they're going to look out for you and help you get to that point where you can retire and live off of your money. So what could be more important than that? But there are instances where I see that the brokerage industry has sort of set this field up such that they've got an advantage, both in terms of how the investments are structured, the commissions, the money they make off of you. And so there's just information that I wish more of the investment public had, questions that you could ask to even that playing field and make it a more productive relationship. And so each week, that's what we're sort of going to try to tackle, is either, information I've picked up from other cases, things to be on the lookout for, or if you've already arrived at that point where you think maybe you need to do something, information on the arbitration process generally, because that's what you would be in, is if you had a dispute with your financial advisor. There in the fine print of your agreement is something that says that you waive your right to sue them in court, and instead you've got to sue them through what's called FINRA arbitration. It used to be called the NASD. And that's what we do, is exclusively FINRA arbitration cases. And that actually is the topic this week, is a discussion of, in terms of you've decided, okay, I need to bring a claim. What would then be your discovery requirements, the requirements on you of the documents that you would need to produce in that type of dispute? What other information do they get to ask you questions, et cetera? Because I, in my experience in talking to people who are considering bringing these types of claims, that is often the biggest hesitation. Usually by the time they get to us, they're sufficiently mad. That's not the problem. If you're calling a securities lawyer, you're probably at that point where you're mad enough where you're willing to pull the trigger and bring a claim. But I think people are both concerned about their ability to win. What are the odds that I'd actually prevail? But also, what are my obligations? I'm obviously hiring a lawyer, talking to you. What are you going to handle? What am I going to have to do? And so, fortunately, there are FINRA rules that limit discovery relative to court. And so, that's sort of the short answer to clients. But beyond that, there's also documents that are required of people in every case. So that's what we're going to tackle. The first thing that I think scares some investors away from being willing to bring a case is the idea of being deposed. Let's say you've never been involved in litigation, and you don't really like the idea of sitting across the table from your adversary's attorney and being grilled for several hours with them asking you a bunch of questions, and you can't really get up to leave or what have you. The nice thing about FINRA arbitration is that there are some exceptions, but for the most part, depositions are not permitted. FINRA arbitration generally as a alternative dispute forum, the objective is to be more streamlined, less intensive, and depositions is one of those big things, where there's generally not going to be a deposition, so you generally don't have to worry about that. Now, obviously, if you went to a hearing, you don't settle a case, you go to a hearing, you're, of course, going to be cross-examined. You are going to have to answer questions from your adversary's attorney. But the vast majority of FINRA cases do settle. I think the numbers are about 80%. So for a lot of people who bring these types of claims, they would not have to be deposed. And that's something I think people are generally frightened about. So then we've taken that potentially off the table. What are your requirements then in terms of producing documents? And for me, this is the big one where we have that discussion with potential clients and we tell them, look, obviously we can draft the statement of claim and we can review the answer and we can work up your case. And obviously we're going to be the ones that try your case. But where I really need you is at a hearing where you're my key witness and during the process when we need documents because you have them. And there's certain documents that we're going to need both to prove your case, but also certain documents that the brokerage firm is entitled to. And so for clients, that is usually the biggest obligation for them is obviously at a hearing testifying, but before then, because most cases settle. So the one that's going to happen in every case is the documents. What documents are you going to need to get? And how voluminous is it and how onerous is it, et cetera. Those are the questions that we're generally being asked. And again, the nice thing is because we're in arbitration as opposed to court, it is generally limited. And historically, it's been done by FINRA rule. It started the first time they sort of made it uniform because what was happening is you had brokerage firms and investors fighting about what they wanted to produce in all these cases, which created motions to compel production and fights over it and arbitrators having to step in. And so, again, that sort of runs counter to the general objective of arbitration, which is to streamline this and try to make it easier. And so what FINRA would, and at the time it was called the NASD, what they did is they stepped in, they tried to sort of uniform it. They got together with lawyers who represent brokerage firms and they got together with lawyers who represent investors and they got them together and said, okay, here in this room, what can we agree that you need in every case so that we don't have to fight about it? Here are the documents that brokerage firms have to produce every time. Don't fight about it, just produce it. And they're documents that are considered presumptively discoverable. And then on the investor side, what are the documents that would need to be produced in every case? Don't fight about it, just do it. And these are the documents that are presumptively discoverable. And there's a list, and it's called the discovery guide. And that is sort of the baseline of what your obligation is going to be in every case. That started in 1999. It's evolved sort of in terms of its use and its process. And it was sort of changed and made whole in 2011 when FINRA came out with, they issue these all the time. They're called notice to members, which is a notice to the brokerage firms that are FINRA members. But they came out with Notice to Member 1117 in 2011, which sort of established definitively, okay, here's the discovery guide. And now you don't even have to ask for it. 60 days after you file, the answer is filed, here's the documents each side is required to produce. And there are lists. And so if you're filing a customer case, you look at list 2, I'm a customer, here's the documents I need to provide. So that's sort of the historical background of where we're at in the baseline. This is what we tell clients. Okay, let's go to the list. Here's what you're going to have to produce. Are you comfortable doing this? Because if you're not, don't bring your case. This is sort of the bare minimum. We're going to take a quick break. And when we get back, I'll go through what that discovery guide is and why, again, the machination of this was you've got lawyers on my side of the fence and lawyers on brokerage firms getting together discussing, okay, what do we need in every one of these cases? Here's the documents we need. And we'll go through the basics of what those documents are and why. Why would you need them? Because for some of them, and tax returns is the big one, but for some of them, we get pushbacks from clients all the time, like, why do I have to give you that? So we'll go through that when we get back.
He got to the point where he could barely work. The pain in his back going down his leg was so bad, we were afraid he needed surgery. But we went to the Pro Spine team of doctors. They were able to put him on pain management and physical therapy, and he is so much better now without surgery.
I had been told I had disc damage, which meant surgery. I went to Indian River County's fellowship-trained spine surgeon, Dr. Johnny Benjamin at Pro Spine. If you have to have surgery, then you want the best.
Pro Spine in Vero Beach. We've got your back. 1-800-HI-MITCH. What's that number and who is Mitch? 1-800-HI-MITCH is the number for Mitch Maxfield's Carpet and Furniture Cleaning Services. Serving Florida's Treasure and Space Coast for over 30 years, and Mitch still does the work all himself. Call 1-800-HI-MITCH. Mitch Maxfield personally will clean your home or business. Call now for 2 rooms of carpet cleaning for $77 or a 6-foot sofa for $66. Maxfield Carpet Cleaning is a member of the iTex trading community and welcomes your iTex dollars. 1-800-HI-MITCH.
Listening to Wall Street versus Main Street. I'm your host, Dax White. Before the break, we were talking about the basic requirements of any investor who decides to bring a FINRA arbitration claim against their financial advisor or brokerage firm. And we talked about sort of the history of how we've arrived at this baseline of documents that are presumptively discoverable in every case. And while this doesn't completely encapsulate the list and it doesn't preclude brokerage firms from asking for additional documents, these are the bare minimum. These are the documents you have to produce in every case. And in my experience is, generally speaking, this is what would be required to go try a case from a brokerage. They're going to ask for more stuff because they're paying their lawyers a bunch of money. They got to do something. But a lot of those additional requests, in my experience, are sort of out in left field. Hey, let's ask for it and see if they don't fight us on it. But we often do. And we often cite back to this discovery guide and say, look, this is what's presumptively discoverable for a reason. And these additional documents you're asking for are not relevant and it would be overburdensome for our client to go get them, et cetera. Which isn't to say there aren't reasonable requests. Of course there are, but the discovery guide, that notice to member I talked about before the break, that establishes what the documents that are presumptively discoverable in every case, there's a reason. Again, the history is that you had lawyers get together, talk about, okay, all right, well, what do you need to try this case? Yeah, all right, I know you need this, I know you need that. And let's agree on, okay, here's the documents we're going to produce every time. And that's, again, the FINRA discovery guide. And so when you're contemplating, I think I've been taken advantage of, am I willing to actually go through the process? And for our clients, a lot of that is, okay, well, what am I going to have to do? And for the most part, it's get us the documents we're going to need, the documents that you're required to produce. And so we'll run through what those are, but overall, what I would say is the documents that you are required to produce are the documents that a brokerage firm would need, because almost all these cases, what you're alleging is that the investment recommendations were unsuitable for you, that the financial advisor breached their fiduciary duty to you in recommending investments that you didn't understand or you didn't have experience for, or were just over-concentrating your portfolio, et cetera. And so the documents that you would need from the brokerage firm standpoint to either verify the validity of your claim and say to their client, hey, we need to pay on this one, or to try to disprove those allegations would be all the documents that would basically establish your investment experience, your income, your net worth, your investment objectives, which is usually looking at previous investment experience, because that would be suggestive of, okay, you've done this in the past. You were probably willing to do this again. So it's basically all the documents that would go into what's your investment history, who are you as an investor, what's your background, your education, those things. So each of the ones on the list, I mean, they're on the list because they would provide some of that information. The first one, and the one that is typically the most controversial, at least with our clients, because people are just very protective of their tax returns, is tax returns. And what we hear from clients all the time is, and particularly in the world that we're in right now, where you have people filing fraudulent tax returns, and you just don't want that information out there. And so I understand that component of it, but also people are just protective of the information. They don't want people knowing how much money they make. They don't want people knowing, they're concerned with who's going to see these. And this is an aside, but generally speaking, in these types of cases, there are confidentiality agreements that are entered into, because both sides are sensitive to this information being out there. And what it does is it essentially limits this information to the arbitration hearing only, and it can't be used for any other purpose. So to the extent that you give the tax returns to the brokerage firm, it's so that the lawyer on the other side or any business people that he would need to consult with an expert or whatever can review them. And that's the extent of it. But the reason they're relevant, the reason, we tell clients, look, we could object if you want to, but my guess is that ultimately you'll be required to produce them because they're the number one item on the presumptively discoverable document list. But also, more importantly, if you don't, there's probably going to be some negative inference made by the arbitration panel that you're hiding something. So certainly we suggest to clients that, I understand your reservations. Let's try to protect your confidential information, but we certainly suggest that you do produce these. And the reason is because a lot of the information that goes into determining whether or not these recommendations that you're holding the brokerage firm responsible for are appropriate for you, a lot of that information is in your tax returns. I mean, you're obviously going to have your income on there. And income is certainly a component because let's say you're a 35-year-old doctor making $500,000 a year and you're filing a lawsuit over a $50,000 investment. Your income is going to be important because an arbitration panel might look at that and go, well, that's such a small percentage of his income, not even his net worth, but his income. Maybe he was willing to take a risk on that particular investment. Juxtapose that to somebody who makes a $50,000 investment, but they're retired and have no income. That's probably somebody who is willing to take on less risk. So, income, that's on your tax returns. That would certainly that's the reason that's important. But also in your schedules, your K-1s, you're also going to have reference to other investments. And that is another component of determining both the validity of your claim and from the brokerage firm's perspective, trying to defend that claim. It's looking at your investment history. If you're filing a claim holding a brokerage firm responsible for recommending that you buy XYZ oil and gas limited partnership, and you're arguing it's super high risk and outside of your investment objectives, not what you wanted, but your tax returns reveal that you had done 4 other investments exactly like that through another brokerage firm, I mean, obviously that's going to be critical information to their defense. And that would be in your K-1 because you would be getting distributions from that investment. So that's why the tax returns are important. That's why it's number 1 on the list. And again, that for whatever reason, and I do get it, but that's the one that we usually get the most pushback on. The next one is financial statements, and not every investor has this one. There's not a lot of people out there that are constantly tracking their net worth and have updated financials so that if they get into a lawsuit, can just print it up and send it to us. And so, that's it brings up a critical point, which is that FINRA rules do not require you to create documents. You either have it or you don't. And so if we come to you and say, hey, you got to give us your financial statements, if the response is, well, I don't have a financial statement, then that's the answer to the brokerage firm. These people don't have one. And so that does happen in a lot of our cases, but where we do see them, not necessarily somebody who's sitting at home tracking their net worth, but where you would potentially have a financial statement is, let's say you tried to take out a mortgage in the last couple of years. Bank is, in that context, usually going to have you fill out a financial statement. If you have a copy of it, or you can get a copy of it, then that would be a document that would be responsive. And ultimately what the brokerage firm is looking for is something that would be pre-litigation, you making a attested to statement about what your net worth and your financial situation is, as opposed to maybe what they would argue would be a self-serving representation of what that situation looks like now that you're involved in litigation. They want to see one that, was created before the dispute. And so that's why they're looking for that one. And the reason, of course, that it's relevant, it goes back to suitability again. Goes back to what you're typically arguing in these types of cases, which is that the recommendation was inappropriate. Again, if we're talking about that 35-year-old doctor who makes $500,000, and oh, by the way, he's also worth $5 million, and he's making a $50,000 investment, that's information the brokerage firm's going to want because they're going to look to the panel and say, look, this was clearly a suitable investment. It didn't work out. We're sorry about that. That's not what we hoped. But for somebody to put, 0.1% of their net worth or, whatever the number might be in this investment program is not unsuitable for us to make that recommendation. So that's why the financial statement would be relevant, and that's why it's on the list. The next one I think is pretty obvious to most people, and that's going to be the correspondence between you and the brokerage firm. Obviously there's going to be documents that are relevant in there in terms of discussions maybe you have in the brokerage firm where there are emails where you were saying, hey, I don't really like that. I think it's too aggressive. I don't want to do that. I mean, that's one you're going to want your lawyer to have. But the brokerage firm, they want to see them all because maybe there's one in there that's like, yeah, I understand those risks, but I want to do it. Sounds great. Let's do it. And so, correspondence between you and your financial advisor or you and the brokerage firm, that's obviously going to be relevant. You're going to have to produce that. The next one is going to be account statements with your other brokerage firms. And sometimes we get pushback on this too, because, again, people are just very protective of their personal financial information. But again, it goes back to that same analysis of trying to determine whether or not a recommendation is appropriate for you. And your investment experience is in play. Again, if you're trying to hold brokerage firm A responsible for, an unsuitable investment strategy, but you're over at brokerage firm B investing in the exact same investments, good luck. I mean, that's going to be very difficult because the brokerage firm is going to argue, no, we weren't doing anything unsuitable. You're doing exactly what you asked us to do. This is the type of investor you are. This is the risk that you're willing to accept by evidence of the fact that you invest exactly the same way at a different brokerage firm. And we're not talking necessarily about same investments. We're talking same strategy, because maybe the strategy worked at brokerage firm B, and that's why you're not suing them. But performance is not what's at issue in these types of cases. What we're talking about is suitability. What we're talking about is strategy. And the mere fact that, I am willing to do that, but you guys lost me money. That's not going to be a valid claim. So again, that's why it's on the list, because the brokerage firm is trying to figure out, okay, who is this person as an investor? And they're trying to figure out, okay, what's their investment background? The perfect case, and there really are no perfect cases, the perfect case is somebody who has no investment experience, no other brokerage accounts. They had CDs. They walk into a brokerage firm. They get put into horrible investments. They lose money. And then they're so freaked out by the market that they then put that money under their mattress. And so your response in that one is, I don't have account statements for other brokerage firms. But most investors, that's not the case. Usually this isn't your first investment relationship with a financial advisor. You moved for whatever reason, you moved. Now you're with a new one, and they want to see, okay, what's your investment history? Because that is usually suggestive of what type of investor that you are. So that's why that one's on the list. The next one is going to be the documents, agreements that you have with the firm. Certainly anything that is with respect to the transactions. And I'm not going to hit them all. So I do want to mention that if you want the full list of what's required, I'm going to sort of do broad strokes. Here's the big ones. Here's the ones that people often have, because there's some that it's on the list, but you don't usually have them. But if you want the full list, go to our website, wallstreetvmainstreet.com, and look for this particular episode where we talk about discovery requirements. And I'll put on there the actual notice to member 1117 that breaks these down. But anyway, the next one, and I'll just mention it because it's a perfect example of one where clients don't usually have it, but it is on the list. And if you do have it, it certainly would be relevant. And that's an account analysis. Some people sit at home and they track their investments, look at performance, and they break it out, and that would be called an account analysis. And if you're somebody who's doing that, I mean, certainly that would be relevant because it's going to show damages. It's going to show how much you're actually involved, because that is certainly representative of somebody that is tracking their portfolio very closely. How often are you updating it? So that's something that would be relevant. That's why it's on the list. I would say that most of our clients don't fall into that situation. It's very rare that any of our clients would actually have this, but it is on the list. Next one would be notes. Certainly if you had meetings with a financial advisor and you took notes, that would be important. That would be relevant in part because I think financial or arbitrators look at contemporaneous notes well before litigation as potentially even more significant than something that might be written or testified to, because you're writing that long before you even thought about suing your financial advisor. Next one would be statements of claim. And if you've sued a previous financial advisor, you're going to have to produce those, because that would, certainly if you were making the same argument before, now you're making it again, that would be relevant. The next one would be documents showing the ownership of a business. Again, that would go towards sophistication, would go towards your general work experience, because, again, it would be hard to argue that a financial advisor took advantage of you if you are a CEO who's run very successful businesses. And the last one that I'll go into is resumes. And that's because it just, for the same reason, it breaks down your investment history, or not your investment, your work experience, and sort of, obviously if you've got a MBA, that's going to be relevant. So that's the basic list. Like I said, if you want to look at the rest of them, check us out on the website, wallstreetvmainstreet.com. And tune in next week as we tackle more topics on this same basic subject. Thanks.
You've been listening to Wall Street versus Main Street. The views expressed by the participants of the program are their own and do not represent the views of, nor are they endorsed by, the White Law Group, its officers, directors, employees, agents, representatives, shareholders, nor any of its subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.